So if we remember, in this case, Mr. Heller not only was not allowed to own a handgun, but even if he had it at home, it had to be rendered inoperable. He had to either have the trigger lock or be taken apart. He couldn't use it. Scalia's opinion contained this controversial dicta. Dicta is a legal term which just means that it's extra. It wasn't really important to the case or vital, but he threw it in there as extra. Remember before I was talking about the judicial restraint versus judicial activism? Well, here's the activism part. Scalia threw this in. Nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons, on the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. There we're okay. Yeah, if you're a felon or you're mentally ill or sensitive places. Then we got this extra part. Or laws imposing conditions and qualifications on a commercial sale of arms. Well, that word qualifications, that's a big word when you're looking at gun control. We'll see that further on. So Scalia threw that dicta in there. The gun rights fans, they love District of Columbia versus Heller because it was good in their opinion, where it says that you have gun rights, Second Amendment protects your right to self-defense, own a gun, etc. The people who are against gun rights, they love this paragraph. With good reason. Because Scalia said, nothing in our opinion should be construed to cast any doubt on long-standing prohibitions on the mentally ill, conditions on buying guns or who can buy them or where you can have them. Okay? In the end, Mr. Heller got his license. There he is. And there's that red velvet bag there. And there's his gun. And one of the things that catches my attention in this is that he's got his wallet with the rubber band around it. You know, there's a certain type of man that does that, and he was that guy, right? And then the other thing is on his tie, he's got the scales of justice on there. That was a really good picture. He looks pretty happy. So he got his license. One of the keys in this case, Mr. Heller said, hey, I should be able to have a handgun, I should be able to have it at home, and I should be able to use it at home, not rendered inoperable at home. Well, one of the things he did not challenge was the government's right to require him to get a license. He didn't argue against that. He didn't say yes or no. Therefore, the court didn't decide whether a license should be required or not. They just said, okay, well, I guess you don't care about the license, so we'll allow District of Columbia to require a license still, and they do. Okay. Here's what Heller held. That the Second Amendment provides an individual right. It decided once and for all, it's not a collective right. You don't have to be in a militia or be part of a group. It's an individual right. Just by being a human being, you can have a gun. It's unconnected with the militia. You can use guns for traditionally lawful purposes. Self-defense, obviously. Self-defense in the home, even more obviously. Hunting, stuff like that. The total ban on handguns was invalid. That was decided. The requirement that guns in the home be rendered inoperable, also unconstitutional. Okay. So it didn't say a 9-shot revolver is allowed, but it's okay to restrict a semi-automatic Glock. All that this case said was a total ban on handguns is invalid. That's all it said. There's a limit. If there's a limit on types of weapons that are not in common use, that's okay. Why was that? Well, Scalia had to get around this other case called Miller, where the Supreme Court in the past had allowed Congress to restrict sawed-off shotguns. Congress and the federal law prohibited the transport of sawed-off shotguns. The way Scalia preserved that precedent is he said, okay, well, sawed-off shotguns, they're not in common use. So it's okay to restrict a type of weapon that's not in common use. Similarly, a type of arm is protected if it has some reasonable relationship to the efficacy of a well-regulated militia. So a gun that you wouldn't use in a militia is probably not protected. A lot of gray area there, but that was another thinking behind the sawed-off shotgun ban. It's not a common weapon, and if I got called up in the militia, probably not bringing my sawed-off shotgun. Okay. Now I know some of you gun types that are thinking, if I got called in the militia, I wouldn't be bringing a 9-shot 22 revolver either. Okay, that's what I think, right? But the key is though that the way Scalia got around that was like, well, the 9-shot 22 revolver was allowed not necessarily because it's so strong for the militia use, but because it's strong for the self-defense use. What he identified was that the handgun, as a class of weapon, was the overwhelming choice of Americans for self-defense. Therefore, it would be unconstitutional to do a total ban on an entire class of the quintessential self-defense weapon, the handgun, even if it's a 22. Okay. That's what Heller did hold. Here's what it did not hold. There's a lot that it did not hold. It did not say that any person at any time can have any weapon. Specifically, in that dicta we pointed out, felons, mentally ill, we can probably restrict those. Sensitive places, post office, school, stuff like that. Exotic weapons. Remember, only the weapons that are really in common use and or could be applicable to use in a militia, those are protected. Exotic weapons, flamethrower, no, probably not. It did not hold that there's a problem with restrictions on commercial sale or transfer. In fact, Scalia said, yeah, we can restrict, we can qualify what type of guns can be sold or transferred. It did not hold anything about a licensing requirement or registration requirement, and it did not hold anything about operability, meaning the trigger locks and stuff, in a non-residential place. All it said was Heller's got to be able to use his gun and have it operable at home. It didn't say that you have to be able to have a weapon operable at all times or in a public place or anything like that. Also, it didn't say that citizens have a right to use the military weapons. That's a gray area too. We'll come back to the military weapons when we get back to gun control. Okay. McDonald versus Chicago, not in a reading. We'll go over this quickly. The day after Heller was decided, Otis McDonald, he was in his 70s. He's been a community activist for a long time in Chicago. A lot of drug violence in his neighborhood. He thought he'd be safer if he could have a gun. Similar to DC, Chicago had this system where in order to have a gun, you had to have a registration. However, they didn't allow any registration of handguns. Therefore, it was essentially a total ban on handguns. So it was the very same case to Mr. Heller. Mr. Heller, though, he lived in DC. So he was challenging the federal government's right to do a total ban on handguns. Otis McDonald, he lived in Illinois. He's saying, hey, Supreme Court, the Second Amendment should also prevent Illinois from doing a total ban on handguns. The Supreme Court applied the selective incorporation doctrine. If I was feeling ornery, I would ask Andrea to state the selective incorporation doctrine right now. I bet you she could. What it is if you look, is a constitutional right, is it fundamental to our scheme, meaning in the United States? Is it fundamental to our scheme of ordered liberty? Or Is it deeply rooted in a tradition and history of the nation? If so, then it's a fundamental right. So, is the right to keep and bear arms fundamental to the concept of ordered liberty? Yeah, probably, because the idea is you have the militia available to quell insurrection or defend against invasion and stuff like that. Is it deeply rooted in the history and tradition of the nation? Absolutely. Bearing arms, certainly. The frontiersmen, the colonists, everything. So, given that, it seemed pretty obvious under a selective incorporation analysis that the right to keep and bear arms would be a fundamental right. The next part of that is under the 14th Amendment, which is one of those that came out of the Civil War, where basically the 14th Amendment was to protect blacks, to say that states can't go and make laws that would discriminate against blacks under the idea that, oh, well, we're states, we're sovereign, we don't have to do what the federal government says. The 14th Amendment is saying that, or at least under a selective incorporation, these federal rights, they also restrict the states. Okay. So the Supreme Court in this case held, yeah, the Second Amendment binds the states. So Chicago's gun ban was also found unconstitutional as to the states. So all that is really good news if you like gun rights. None of that stuff was really known. District of Columbia versus Heller was in 2008. I mean, this is 2 centuries the nation has gone on. We didn't know if the right to own a firearm was an individual right or not. And it took a couple years later to know whether states could do a total ban on firearms or not. Let's revisit these concepts. Federalism, we looked at that. Yeah, some things are federal, some things are state, some things are both. Incorporation, that was McDonald versus Illinois. Federal right, incorporated, or in other words, applied against the states. Originalism versus the living Constitution. Scalia looked at things like the first laws of the state of Delaware from 1789. He looked at Blackstone's. He looked at a document from England from 1689 to interpret what the Constitution meant. That's originalism at its finest, right? Whereas the living Constitution guys, they might have said, well, it's the 21st century, we don't have militias, we got great police forces now, we got helicopters, we got drones, we don't need the citizens to be armed. That would be the living Constitution method. But Scalia won the day in the originalism. Stare decisis, this is a concept that the judges should not overturn precedents willy-nilly. So that Miller case that invalidated the short-barreled shotguns, they had to work around that. Judicial restraint. Scalia was restrained in the sense that he didn't list all the possible permutations of the Second Amendment. All he did was say, Mr. Heller, you get your license. That's it, okay? But he did throw in that paragraph about nothing in there should cast doubt on the other gun control stuff that's out there that I know is out there, okay? But that was dicta and it was extra because Mr. Heller was not mentally ill. He was not a felon. He was not asking to carry his gun in a sensitive place. Nevertheless, Scalia did cross the line into the judicial activism a little bit. It's not the first time Scalia's let us down, by the way.